This is the matter of Sway Amprakash against Kemeth, case number 23-08759 DM. Both parties are present along with their respective attorneys. We are here on the defendant's motion, on the defendant's motion in order to show cause against the plaintiff for contempt. Mr. Young.
Thank you, Your Honor. I'm not sure if you would like just a brief opening summation of what has brought us here this morning, but
it's your time. I mean, I've got the briefs, so
okay.
It's really up to you how you want to proceed.
Thank you. I would just indicate that I would rely upon the allegations set forth in the brief. The court is well familiar with these parties and this matter, and the parties, as you know, do not reside in the same country. The defendant father is in India, plaintiff mother is in Michigan, and so the contact he has had with his child has been through telephonic communications, and he has also visited on the summer for 1 month, and that is scheduled for this summer, hopefully, and it goes well. There has been a very clear direction given to the parties about cooperating with and setting up these calls that are really the sole source of contact between the minor child and the father. They are important, and my client has been very diligent in making sure he is available for those calls. And I think the proofs will show that in nearly all of these calls, there is no video. It is turned off immediately after the calls start. This has occurred while the mother is clearly present. And so our contention is that pursuant to the February 28, 2025 order, that the calls were to be facilitated by the plaintiff is not being properly complied with. Additionally, it is our claim that the mother has been taking the child for evaluations, which as the sole legal custodian, she is certainly entitled to do. But in those evaluations, there are statements and other facts that have been included, clearly indicating that the minor child has been put in a position where things have been communicated to him that result in him making false
This hearing isn't about who gets custody, it's about whether a court order was actually followed. The father argues that repeated problems during video calls, along with comments allegedly made to the child, have damaged his relationship with his son. The mother's side disagrees, saying these are ordinary challenges that come with long-distance parenting and a very young child. The judge now has to decide whether these issues amount to contempt of court.
Negative statements about his father. That clearly is in violation of the court order that would prevent plaintiff mother from saying anything to this child that is going to disparage the defendant father or put him in an unfavorable light. I think that if the court were to look at the history of this case, the mother has and continues to claim that the father is unsafe to be around the child. That has been related to numerous in pleadings before the court. I do believe that those are not based on any kind of factual basis. And so it makes the courts implementing a relationship or allowing a relationship to flourish between the son and the father next to impossible if there is this continued notion and narrative about the defendant being a danger to his son. So based on that, we are wanting to proceed with this contempt hearing and ask the court, after hearing the evidence and considering credibility of the parties, that it make a determination as to what sanctions should be ruled against on the plaintiff's part. And included in that is, again, attorney fees for the defendant, who has, and I believe this is the fifth motion that we have dealt with. I believe the court has been very generous in giving mom the benefit of the doubt in prior actions. But I know that in Ingham County, there was clearly a determination that mom was not cooperating, and there was attorney fees imposed in that one instance several years ago. I don't have the exact date. So we are ready to proceed with the proofs from the defendant father on what has occurred concerning both the calls and the disparagement claim that he believes is contrary to the orders of this court.
Thank you. Ms. Neisler.
I think I'm going to emphasize that this is, I believe, actually the sixth time we have been here, and the last five, there's not been a finding of contempt, and we're looking at the same allegations. At the end of the day, what we're dealing with is a 6-year-old who's doing video calls, and I don't think there's anything deliberate, and I don't think he's going to be able to prove that mother is deliberately interfering with these calls. The parties have a tumultuous history, but I know since I've come on board, there has been what I would call meticulous compliance with the orders, and that I hope will continue. And I'm not seeing that a child turning off the video and then a half-hour phone call continuing to occur rises to the level of contempt, that we're dealing with a very young child in a very long-distance relationship. As far as the allegations about what mom is saying to the therapists and saying to the child, I think my first issue is that I don't see the therapist on the witness list. So we're going based off of hearsay contained within a report that's not admitted, and certainly I hope would not become part of the record even if we were to do. So if we do get to the point where the court is considering admitting that report, I'd ask that we do it under seal, just as sort of an aside so that the child's evaluation. But it's an evaluation that was deeply contemplated last time we were in court, as far as selecting the provider, giving dad the opportunity to participate, ensuring it was someone who had the remote availability. So I will, based on how the testimony comes out about that, I will have more or less to add when I take my hour and a half that I hopefully don't need all of, but that should give the court a bit of an idea of where we're going in our theory of the case.
All right, thank you. Mr. Young.
I would like to call the defendant father, Ayud Kamath, if I could.
All right. Sir, would you unmute? And would you raise your right hand? Would you state your name for the record and spell it?
My name is Ayod Vasant Kamath, AYODH-VASANT-KAMATH.
Do you swear or affirm the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Mr. Young.
Mr. Kamath, could you tell me what your relationship is or was to the plaintiff in this case?
We were married.
And you were divorced?
Yes.
And when you were married, were you residing in America?
Yes.
And did there come a time when you were no longer allowed to remain in the country?
Not really. I had to move back to India during my PhD for family reasons. My mother had been unwell, and I needed to move back to look after her, and she passed away shortly after that. And I needed to remain here to settle her estate and various other financial and professional obligations, and sort of carry all of them out. And after a certain point, so that's
okay. And with regard to your desire to come back to the States and live in a closer proximity to your son, is that possible now?
Given what we are seeing with the changes to H1B visa rules with ICE and other things, and the increasing sort of undermining of the law by the federal government, I would say increasingly no.
So what is
I have in the past applied for jobs soon after my for a year or two after my PhD was completed, but yeah, at this point, I have not actively been looking. It's been 5 years. It's been 4 years,
So,
roughly 3.5, 4 years now.
so you are not in the foreseeable future going to be relocating to the States, living in the same community as your son. Is that correct?
I don't think I'm going to be able to. Yeah, even if I did, even if I tried, I don't think I'd be able to. And so it would take a lot of time, effort, and money to do that, which, given the odds of success, don't really balance out
Okay, so
professionally. So, yeah.
you, other than 1 month in the summer that you come to visit your son, what is the contact that you are able to have with him?
Other than the 1 month in person over the in July, it is the twice weekly calls on Friday and Saturday evenings Eastern time, which are the middle of the night, my time.
And how long has the court ordered or allowed you to have those calls with your son?
Since the divorce, but there was a period, I think in 2019, there was a period in 2020-ish when, for a while, when the calls were not happening, and I think that is when a contempt of court
I'm going to object to
was
testimony
found.
about anything that happened prior to the last time the contempt motion was denied, and ask the court if we can limit things to the dates in question, which started in October of 2025.
Mr. Young?
I will move on if the court please.
The court's aware of the history of the case.
Yes, so I'm wondering if, in your experience, since we were last in court over the telephone calls, I believe that was a year ago, maybe longer, have those calls gone smoothly?
Not really, no.
And could you describe for the court, if you could, and in particular, what you have attached to your motion as a summary of calls from October 3rd of 2025 through March 14 of 2026. Are you familiar with that summary of those calls?
I'm not familiar with the exact happenings on each call, but broadly speaking, I've tried to summarize whether the video was on or off at the start of the call, how the call was being set.
Now the case shifts from legal arguments to evidence. The father has created detailed records of more than 40 video calls, claiming they show a consistent pattern of interference. Instead of relying only on memory, he's asking the court to review the actual recordings. In family court, evidence like messages, call logs, and videos can often carry much more weight than accusations alone.
Up and whether, yeah, and basically I've focused on whether or not the calls have been set up, whether the camera was pointing at Matsya at the start of the call or not, whether the video was on at the start of the call or not, whether the audio was on at the start of the call or not, and if the video was switched off, under what circumstances they were switched off at the start, during the setup of the call.
Okay. Now, that is a summary that you prepared. Is that correct?
Yes.
And that was prepared contemporaneous to or simultaneous to the call concluding. Is that a fair statement?
I'm sorry, I don't quite understand the question. Sorry.
What I'm wanting to know is whether the summary that's attached to your motion is an accurate representation of what you just testified had occurred during each of those 43 calls.
To the best of my abilities, yes.
Yes. And if you could, can you tell the court if your ex-wife, the plaintiff in this case, was involved in the setting up of those calls?
In some calls, I could tell whether that she was. and in some in some calls where the video was visible at the start, I could see her. Some calls, even when the video was not on, I could hear her. So with some days the audio and video were both off at the start, so I didn't really know. So, but yeah, I don't know if that does that answer your question.
Right. I'm just wanting the court to understand with these 43 calls, how many were problematic and how many were successful, correct?
I don't remember off the top of my head, but there are, like I said earlier, there are different parameters which I've tabulated, and different calls had different issues.
Now, you conduct these calls on Our Family Wizard platform, is that correct?
Yes, that I believe it was this court that directed us to switch from, I think it was Zoom earlier. Before that, it was Skype. So yeah, and right now we're on OFW. Yep.
So OFW retains a video of all of the calls that you've listed on your attached exhibit to your motion?
Yes. I think you need a specific kind of account that you have to pay extra for to access them, but yes.
And so you are prepared and are willing to present to the court the video from all of the calls you have attached, both 1 through 43. Is that a fair statement?
Sure, yeah. And as my lawyer, you also have access to my account. So I believe that the recordings in your possession were directly downloaded from the site without my intervention in any way.
Okay. So of the calls that you would like to have the court have its attention drawn to specifically, can you identify just some of the worst examples, I suppose, of the plaintiff's interference with these calls or inability to facilitate the calls?
Sure. If I could I don't remember the dates off the top of my head. I'm not very good with numbers, but if you allow me, yeah. So, I mean, 27th February of this year is one of them. Then there's 13th of February, 28th November last year, 20th December last year, 31st October last year. These are just some of them which show different kinds of issues that have happened.
So in each of the calls you've just mentioned, do you see your son in the video call? Is his face there?
In a few of them, yes. Some no. It depends. So I have focused on the setting up of the call rather than what happens later on in the call in terms of my tabulations. In the setting up of the calls, in some instances, the video has been off at the start. In some, the video has been on, but it's not been pointing at Matsya. It's in one instance, it was pointing, I don't know, at some unidentifiable objects. In another, it was pointing at Ramya, and then it was turned off before I could see Matsya. So so there are different sort of issues in the different examples.
So with regard to the February 27 video, that is something that you believe demonstrates the problems generally that you've filed the motion about?
Sure, some of them, yes.
Your Honor, I would move to allow or move to have the court consider the proposed video of, I'll just select several, if the court please, and let the court see what has transpired if there's no objection.
You're muted.
Is there any objection? No, you're muted.
No objection.
All right. And we will stop streaming.
As the hearing continues, one question remains at the center of this case. Were these communication problems simply the reality of co-parenting across to different countries? Or did they violate the court's orders? The judge will have to weigh the testimony, review the recordings, and determine whether there's enough evidence to hold either parent in contempt. If you enjoyed this courtroom breakdown, hit that like button, share your thoughts in the comments, and subscribe for more real courtroom drama and legal analysis.